The next up is Senator Cruz of Texas.
Oh, God, no.
Thank you, Mr. Chairman. Judge, good afternoon.
Good afternoon, Senator.
Under Article 3 of the Constitution, federal courts have jurisdiction over only cases and controversies.
Oh, no.
Which means under the Constitution it has to be an actual dispute, that federal courts cannot simply issue advisory opinions on a question they may have a view on. And one component of Article 3 jurisdiction is the requirement of standing, that in order for a plaintiff to have standing to bring a case, that plaintiff, at least generally speaking, must have a real and concrete injury. Is that right?
That is correct.
So, for example, that means that even if I might have a disagreement with some particular policy or some particular law, that I can't bring a case unless I am personally aggrieved by that policy or that law. So, for example, you're in my alma mater, Harvard, is currently being sued for its explicit and, in my view, egregious policy of discriminating against Asian Americans. Even though I think that policy is egregious, I, as an individual plaintiff, could not bring a lawsuit challenging it because I am not Asian American. Is that right?
If you brought a lawsuit, the court would have to evaluate whether you had an actual injury in order to be able to determine whether it had subject matter jurisdiction to hear the suit.
But if I'm not in the class being discriminated against, then I don't have the ability to bring the lawsuit. Is that right?
I think you'd have to have an actual injury. Certainly people, I think, who are in the class could claim that they had an injury for that purpose.
So now you're on the Board of Overseers of Harvard. If you're confirmed, do you intend to recuse from this lawsuit?
That is my plan, Senator.
Okay. We discussed yesterday how the standard for race discrimination was strict scrutiny. The court has laid out a different standard for gender discrimination. What is the constitutional standard that applies to gender discrimination?
Gender discrimination, the court has held intermediate scrutiny applies, which is that the government has to have an important interest and the tailoring doesn't have to be as narrow.
Right. So yesterday, under questioning from Senator Blackburn, you told her that you couldn't define what a woman is, that you were not a biologist, which I think you're the only Supreme Court nominee in history who's been unable to answer the question, what is a woman? Let me ask you.
Have they all been asked that?
Judge, how would you determine if a plaintiff had Article 3 standing to challenge a gender-based rule, regulation, policy, without being able to determine what a woman was?
So, Senator, I know that I'm a woman. I know that
You're not.
Senator Blackburn is a woman, and the woman who I admire most in the world is in the room today, my mother. It sounded as though the question was...
But let me ask, under the modern
Ted, you're an idiot, dude. Let her answer.
If I decide right now that I'm a woman, then apparently I'm a woman. Does that mean that I would have Article 3 standing to challenge a gender-based restriction?
Senator, to the extent that you are asking me about who has the ability to bring lawsuits based on gender, those kinds of issues are working their way through the courts, and I'm not able to comment on them.
Okay, if I can change my gender, if I can be a woman, and then an hour later, if I decide I'm not a woman anymore, I guess I would lose Article 3 standing. Tell me, does that same principle apply to other protected characteristics? For example, I'm an Hispanic man. Could I decide I was an Asian man? Would I have the ability to be an Asian man and challenge Harvard's discrimination because I made that decision?
Oh, my God.
Senator, I'm not able to answer your question. You're asking me about hypotheticals and
Well, I'm asking you how you would assess standing if I came in and said I have decided I identify as an Asian man.
Depends on the case.
I would assess standing the way I assess other legal issues, which is to listen to the arguments made by the parties,
right,
consider the relevant precedents, and the constitutional principles involved and make a
Perfect.
determination.
Perfect answer.
Okay, let's go back to your favorite topic of this hearing, which is the criminal law cases you had as a district judge, and in particular, the cases involving child pornography. Now,
No,
your
that's his
defenders,
favorite
both on
topic.
the Democratic side of the dais and also in the press, have suggested that the criticism that has been raised has been somehow cherry-picked, that it's only some specific examples. So I'm going to give you an opportunity to discuss each and every case you've had, because looking at your cases, and I've now examined all of the child porn cases you've had as a federal district judge, there is a very consistent pattern. So let's start, and by the way, I'm excluding the cases. So Senator Durbin and Senator Coons focused on the Nickerson case, the Fife case, the Nguyen case, and the Hilly case. I'm excluding those because those are not child porn cases. Those are actual sexual assault of a child, which is markedly different. And I will concede when you're dealing with sexual assault, you have been willing to impose stricter penalties. So let's focus on actual child pornography cases. And let's go through each of them, because if it's right that we're cherry picking, then you should be able to explain quite powerfully. Now, your justification is that you're following the statute. And as you know, 18 U.S.C. section 3553 lays out the factors that as a district judge you had to consider in sentencing. And let's start with the Hess case, United States versus Hess. Now, in that case, a man sent 6 pictures of a prepubescent girl that he claimed was his daughter to an undercover law enforcement officer.
Listen to this.
Officers found over 600 images of child pornography, including images of sexual acts being performed on prepubescent children. The defendant pled guilty, and I believe in all of these cases the defendant pled guilty. So there was no question about guilt. They came in and pled guilty in your courtroom. The charge carried a mandatory minimum sentence of 5 years and a mandatory maximum sentence of 20 years. The sentencing guidelines recommended 151 to 188 months sentence. The government, as part of a plea deal, agreed to argue for 60 months, but didn't agree that that would be the sentence, simply that they would advocate it. And you, in turn, sentenced Hess to 60 months. So, under the terms of the statute, why did you choose to sentence Hess to the absolute lowest possible sentence you were allowed to sentence under law?
Thank you, Senator. I have spoken at length throughout this hearing about these cases. I've said what I'm going to say, which is I've taken every case seriously. These are
Do you have anything to
very
say about the Hess case?
horrible
I'm asking you specifically
crimes,
about the Hess
and
case.
I've taken every case seriously.
So you're not going to answer that?
These are very horrible crimes, as was that one. And as a mother, having to look at these pictures, having to follow Congress's directive, having to listen to recommendations like the government in that case, which argued for 60 months, I imposed the sentence that I believed was the sentence that was required by law.
So I believe you, and I've read your sentencing hearing in each one of these cases for which we have transcripts, and there are several of which we don't have transcripts. So in each of these cases, you read from the same script. So in each of these cases, you say that the distribution of child pornography is an extremely serious federal crime. And you point out that the crime involves people who are taking pictures and videos of real children while the children are being sexually abused. In Hess, you pointed out that he had hundreds of images of children in sexually compromised position. Some of them engage in sadomasochistic acts. All of this I'm reading from you on the bench. And most importantly, the children in these pictures are not knowing and willing participants in the degrading conduct that was being depicted. They were being forced by someone off screen to commit unspeakable acts of sexual violence for the pleasure of the people filming them and for the gratification of people everywhere. And what concerns me is that many of those people have absolutely no shred of empathy for what that conduct does for the children who were being abused in this way. And you read this script in every one of these cases. So you talk about that these are terrible, terrible crimes. But you also And in Hess, you said, I have to say that what I found particularly disturbing about your offense was that, quote, you apparently concocted a story about having photographed your own daughter, who you purportedly were willing to take pictures of to trade with other people. I know from your comments and from those who know you that you are unlikely to ever harm a child, which I find remarkable that you've got a child predator in your court who says, I'm unlikely to harm a child. And you say, well, you told me that, so clearly you're unlikely. But you say, but in the context of the crime, you represented that you would. That in and of itself is astonishing. So you talk about it as astonishing. You nonetheless sentenced him to the very lowest possible sentence allowed under law. And what's striking is in these cases, in half of them, in 5, you sentence the defendant to the absolute lowest sentence under law. Let's look at another case. Let's look at United States versus Chazen. Now, Chazen is a particularly nasty case. In Chazen, the defendant was accused, accessed a Dropbox that contained 35 videos and 13 partially downloaded files of prepubescent minor females engaging in sexually explicit conduct. At least 3 of the instances of prepubescent female children were engaged in sexual activity with adult men.
Is this the same thing as yesterday?
Included the sexual abuse of children, including those as young as toddlers. And several of these cases that you had involved the sexual abuse of toddlers, which is truly horrifying. In this instance, Chazen pleaded guilty. The guidelines recommended a sentence of 78 to 97 months. The prosecution argued that should be what the sentence was. And you sentenced Chazen to just 28 months. Why did you sentence someone who had child pornography of toddlers being sexually abused to 28 months, 64% below what the prosecutors asked for?
Thank you, Senator. You've picked out, 7, 8 cases. I've sentenced more than 100 people.
But not to child pornography.
And in every
These are your child
case,
porn cases.
in every case, Senator, I look at the evidence, I look at the recommendations of not just the government, because my duty as a judge is to consider all of the arguments that are made in a case. I look at the evidence, I talk to the defendants about the harms that they have engaged in. Many of these defendants are people who...
Okay, Judge, with respect, you're not answering my question. You're right. You talked to them about the harms. Let me read you again from what you said at the bench. You said in this instance...
Someone should ask for her to be allowed to complete answers, and any of the other senators could ask for that.
...received a below-guideline sentence on the basis of a downward variance as opposed to a departure. The average sentences ranged from 84 to 92 months. So that's what you lay out as the average. Our Democratic colleagues say, well, other federal judges sentence below the guidelines. That is true. A number of federal judges do. Our Democratic colleagues have not pointed to a single federal judge in the country who 100% of the time sentences child porn defendants to markedly below what the prosecution has recommended, unless you have a mandatory minimum and no ability to do so. In this case, you say comparable defendants are sentenced to 84 to 92 months. Sentencing guidelines by statute require you to have similarly situated defendants sentenced to similar sentences, but you don't sentence Chazen to 84 to 92 months. You sentenced him to 28 months. Why?
Senator, I've said what I'm going to say about these cases. No one case can stand in for a judge's entire record.
Okay, but I'm discussing
And
every one of your cases. So if you're not going to explain it, then I'm
Senator,
gonna...
would you please let her respond?
There you go.
No, not if she's not going to answer my
Well, if
question.
you're just going to give a speech, then you shouldn't engage in questioning.
You are not taking my time. If you want to filibuster, you're welcome to do so, but do it
I
on your
would
own
at least
time.
give you an opportunity to speak, and you should give her an opportunity to respond.
If she wants to answer the question, I asked her why
Please
she
allow
sentenced...
her to answer the
I asked
question.
her why she sentenced Chazen to 28 months when comparable defendants, in
So
her
let's
own
hear the
words,
answer.
were sentenced to substantially higher, and she said she's not going to answer. Did you? I would welcome your
I didn't
answer,
hear that.
please.
Senator, I didn't say I'm not going to answer.
Okay, well,
I
then
said
please
my
tell us
answer.
in this case, Chazen, Why did you sentence him to just 28 months?
Senator, you're looking at the record. I don't have the record here. What I will say is that in every case, I looked at the recommendations of not only the government, but also the probation office, the defendant, the record, the evidence. I took into account the seriousness of the offense. And
By the way, you know, one of the
ruled.
striking things in Chazen, the prosecutor comes in front of you and says, this is the prosecutor's argument at this point, and the prosecutor says, I understand from my experience before Your Honor's objection, policy objections to the 2G2.2 sentencing guidelines. And he goes on to say, however, in this case in particular, the 4-point specific offense characteristic is justified because it contains sadomasochistic images of infants and toddlers. I'm trying to understand how you see someone that possesses images of infants and toddlers being sexually violated and you sentence them to 64% below what the prosecutor's asking for.
They still got years in prison. I mean, it's just this is just a weird line. I don't know.
Concerned that the guidelines are too high. You don't provide a justification as required by statute. So I'm asking you to take the opportunity to explain to this committee and the American people why in 100% of the cases, you have people with vile crimes, and you have language saying they're vile crimes. But then you sentence them to very, very low sentences. And why do you consistently 100% of the time choose to do that?
Senator, no one case can stand in for a judge's entire sentencing record. I've sentenced more than 100 people. You have 8 or 9 cases in that chart.
Okay, Judge, you said that before. These are the 8 or 9 child porn cases. I will say, to correct the record,
I'd just say to the judge, there's no point in responding. He's going to interrupt you.
Thank you.
Look, I appreciate the chairman trying to filibuster, and if you don't like your witness's answers, you're welcome to provide your own. She is declining to answer the question, and Chairman Durbin, if you want to join her on the bench, you can. But Chairman Durbin,
My job is to make sure.
Chairman Durbin, I'm not
questions are
interrupting
answered.
your questioning.
I'm asking you to give her a chance to answer.
But
You
she's
refuse to do it.
consistently said she's not going to answer. I want to clarify for the record, by the way, the case I was discussing was Cooper and not Chazen. But Chazen is, the case that I was reading from your transcript was Cooper, but Chazen, all right, let's get to Chazen. I pulled the wrong tab. Chazen is equally horrifying, and you say in Chazen, this is something Senator Graham asked you. So the guidelines lay out different enhancements, and you say repeatedly, and this is true in all your cases, you say you disagree with the guidelines, you think they're wrong. And the 2 guidelines you disagree with is, one, there's an enhancement for use of a computer, and you say the world has changed and now all of these are on a computer. And I understand that. I don't agree with you, but I understand that. That is a understandable thing to say. But the second thing you say over and over again is there's an enhancement for the number of images. And you say repeatedly, for example, in Chazen, you say, whatever the state of the law and technology at the time of the guidelines were first adapted, neither the use of the computer nor the number of images are especially aggravating factors today. Now, I find that bizarre. And you say it in every case. You say the number of images, it's not an aggravating factor, it doesn't matter, and you won't apply the enhancement. Do you really believe that a predator that has hundreds or thousands of images of hundreds or thousands of children being sexually violated has not committed an offense that is more serious than someone that has a single picture of a single child? A single picture of a single child is horrifying. But hundreds of children that have been violated, do you really believe that is not a more serious?
It's interesting because, like, okay, assuming that none of them are pictures produced by the defendant, I think there's a difference between 1 and 1,000 pictures, but is there a difference between 2 and 12? I just don't know. I mean, it's an interesting question.
An enhancement, just not to the degree of the guidelines.
You're
So
right. It's a 5-point enhancement under the guidelines. You provide 2.
Yes, so not 0,
Okay,
not
you're right,
the suggestion that I did.
Are you suggesting the number of images doesn't matter? Because you say it in court over and over again that the number of images doesn't reflect that it's a more serious crime. Do you really believe that?
Senator, as I said to Senator Graham, the court is taking into account a number of circumstances. The commission has done a report about the operation of the guidelines, which enhancements actually reflect different levels of culpability with respect
So
to
let me ask you this, Judge. You said the purpose of sentencing is to distinguish between crimes that are not as serious from truly egregious crimes. Is that right?
No, Senator.
So what is the purpose of sentencing if it's not to distinguish from less serious crimes from truly egregious crimes?
It is to assign proportional punishment. It is to do justice in cases where you have defendants who are convicted of the same conduct, but have differing levels of culpability.
Well, I will point out that you have a pattern. It doesn't matter how egregious the case is. Senator Hawley talked about the Hawkins case where you had an 18-year-old with pictures of boys as young as 8 being sexually assaulted and raped, and you sentenced him to just 3 months in jail. And I will point out the Stewart case, the last one on this list, because we're running out of time.
Thank God.
The Stewart case, you describe that he had over 6,700 images and videos. So that's a lot, 6,700. That's a lot of kids
Time
being
has expired,
sexually
Senator.
assaulted. You have taken over a minute of my time, Mr. Chairman.
I'll give
So,
you-
so
You've been given extra time. You usually ask for it. You're given it.
okay, I know you want to interrupt. I know you don't
I
like
just
this
want you
line
to
of
play by the
questioning.
rules.
I know you like to interrupt, but
I
you've
like you
consumed a
to play by the
substantial
rules,
question of my time of my questioning, and I'm
The
I'm
questions
gonna
are
ask my
actually dumb.
questions, And you can, if you
Senator-
want to testify, you're welcome to.
Senator,
Judge,
you play by the same rules as every other senator.
in the Stewart case,
Shut his mic.
you said from the bench,
She shouldn't even answer.
thus, although this is not necessarily an atypical case, your child pornography possession crime was egregious in the court's view. Okay, so this is a bad one. If you're actually sentencing defendants, you said this was egregious. What did you sentence Stewart for? The guidelines said 97, 121 months. Prosecutor said 97 months. You said it's egregious. 6,700 images. You come in with 57
Time has
months.
expired.
Why
Senators
did
used
you
2
sentence
minutes
him to
over the
just
allotted-
57 months in the Stewart case? Do you want to address that? Because you're claiming it's cherry picking. In fact, you're welcome to explain any of these cases, but let's take.
Durbin's got to take control.
Why
Coons,
did you sentence him for half the amount?
you're not recognized, Senator. Senator
Do
Coons.
you not want her to answer that question?
The time's up.
Wouldn't allow her anyway.
Mr. Chairman, she may answer.
You wouldn't allow her.
Asked her why she sentenced Stewart
You've
an
gone over the
egregious.
time, Senator, by 2 minutes.
Why she,
and a half.
because you've interrupted me for 2 minutes, Mr. Chairman. Will you allow her to answer the question, or do you not want the American people to hear why, with someone she described as
He doesn't let her answer, so what does it matter?
Senator, where you get a little bit.
Chairman Durbin, will you allow her to answer the question?
You won't allow her to answer.
I will happily allow her to. The question is
Senator
why
Coons, you may
did you
proceed.
sentence
Chairman.
Stewart, an egregious child pornography possessor,
Can't they shut his phone
to
up?
half of the amount
Please, Senator.
requested by the prosecutor?
Please, Senator.
Will you allow her to answer the question, Chairman Durbin?
Senator Coons.
Thank you.
Why are you not allowing her to answer the question? There's not
over
another
the
senator
What a
here
loser.
who has not allowed her to answer the question.
You're
I'm not asking another question, but allow her to answer the question, Chairman Durbin.
Thank you, Chairman
Why
Durbin.
do you not want the American people to know what happened in the Stewart case? Or any of these cases? Chairman Durbin, I've never seen the chairman refuse to allow a witness to answer a question. You can bang it as loud as you want.
Well, I can just tell you, at some point, you have to follow the rules.
Okay, will you let her answer the question? You've been interrupting, and
we-
by the way, with Senator Graham, it went 10 minutes over. You've
Sure
taken a
did.
big chunk of the time. Will you allow her to
Escort
answer
him
the
out.
question?
You've given her.
Why
no
are you afraid
opportunity
of her?
to answer.
She's welcome to answer it right now. Will you let her?
Senator Coons.
Will you let? So no, you don't want her to answer the question.
Senator Coons.
Will you let her answer the question?
Chairman Durbin,
Apparently,
Judge
you are
Jeffrey.
very afraid of the American people hearing the answer to that question.
we here
Yeah.
in the